I'm going to call the City of Colleyville Planning and Zoning work session meeting to order for Monday, November 24th, 2025. It is 6:15 p.m. I'll start by taking the roll. David Ebert.
Present.
Richard Remley.
Here.
Jerome Obanabo.
Here.
Jerry Savoy.
Here.
Brandon Arnold.
Here.
Candace Sandifer.
Here.
David Gross is here. First order of business is a legal presentation by the city attorney, overview of Planning and Zoning Commission considerations.
All right, y'all, good to see you. I'll be fast. If you have any questions, let me know, but this is really just a refresher. It's stuff that we've covered before. If you've done your individual orientation, it's been covered there. And it's just really to kind of reacquaint ourselves with things and then also go over just a few changes that we've had a lot of questions about with regards to zoning laws in the legislative session this year. So because Colleyville is a home rule city that regulates zoning, this commission is required by state law. The charter sets forth what the Planning and Zoning Commission's duties and responsibilities are. The primary thing that you guys do are approve and disapprove or make recommendations on to the city council to approve or disapprove proposed changes in zoning, and then also exercising control over platting and subdividing of land. So zoning regulations have to be uniform for each class and kind of building in a district, but the regulations can vary. Obviously, there are specific factors that you guys should consider when making zoning decisions, and the state law does restrict you to those things that you're supposed to be deciding on. While cities can take into account a lot of other things when looking at new developments or businesses coming in, when it comes to you guys' responsibility and duties under the law, we got to stick to those specific things, including the peculiar suitability for specific uses and the surrounding area and how those are compatible. As always, everything has to be in accordance with the comprehensive plan of the city of Colleyville. So these are the things that the comprehensive zoning ordinance and the land development code discusses here in Colleyville. This is what state law allows you guys to consider and the things that are supposed to be making recommendations on. So they must be in accordance with the comprehensive plan, and they must be designed to do the following: lessen congestion in the streets, secure safety from fire, panic, and other dangers, promote health and general welfare. That does not mean your general idea of what's, moral guidelines. It's got to be fact-based. Provide adequate light and air, prevent overcrowding of land, take into consideration concentration. The density term is thrown around a lot these days. And then just making sure that there's enough public infrastructure to serve the number of residents and businesses that are in Colleyville. So we always say that Planning and Zoning Commission should always, and councils too, when deciding on land use issues, always consider the use and never the user. Limit discussions to those statutory factors. Business plans, state licensing of staff, economical benefits, all of those things may be of concern, and they may, come into play with other types of considerations, but within planning and zoning, if they're not, and I'm not saying that these things can't sometimes directly relate to one of the above, but if they don't, then they should not be a factor in the considerations. So the zoning amendment process requires notice of a public hearing. And in state law does say 200 feet, but in Colleyville it is extended to 500 feet. Once planning and zoning holds its public hearing and makes recommendation, then goes to council. If any consideration is denied by the Planning and Zoning Commission, a supermajority is required by council, and that is in the charter. That is not state law with regards to overall determinations like that. So on the bottom, it talks about if owners of a 20% of an area being rezoned or 20% of the area within the 200 feet notice area file a written protest of a proposed rezoning, council can only approve the vote by 75% of the membership. And there's a caveat to that now, due to legislation that was passed just this year. So the proposed comprehensive zoning changes, it is now defined more specifically in Texas law. And its broader zoning actions, including proposals that allow more residential development than existing regulations, and they apply uniformly across one or more zoning districts. Adopting a new citywide zoning code or zoning map, and establishing a zoning overlay district. Those are the things that would be covered by this. But anytime that there's going to be more residential development than existing regulations that apply uniformly, then the 20% supermajority threshold no longer applies. So there's a lot of changes to the notice procedures with regards to these comprehensive zoning, but since y'all don't do that, we won't necessarily go over that with you guys. Let's see. So when there is one of those when there is a zoning change that is not a comprehensive zoning change, the 20% threshold still applies, except for if the zoning change will allow more residential development, and it does not allow additional commercial uses or industrial uses. If it's a mixed use, then the first floor of the residential development cannot exceed 35% of the development's total area. Anyway, all of this to say, when there is not a proposed comprehensive change and the development regulation will allow for any more residential development, the threshold for lodging a valid protest goes up to 60% from 20%. You would think, oh, well now if it's 60%, it requires a supermajority. No. So 60% to lodge a formal protest, but even if 60% protest, you don't need a supermajority. It's just the regular application. So it talks about, the legislation talks about how that land area is calculated for the notice and the percentage of the area that is required to be calculated in that. So I think all of this, just to kind of, I want to keep it in y'all's minds now, and especially because I think that there's probably going to be a lot of questions from the citizenry general population if and when there's a request for a zoning change that would allow more residential development. There is not going to be a supermajority required, even if a 60% threshold is met, unless, because of our city charter, if planning and zoning denies a request, then city council would still have to have a supermajority, but it would have nothing to do with the protest.
Does it make sense?
No,
Just-
it doesn't. Answer that real quick.
It's saying, okay, you have a supermajority if you have 60%, but then it still only applies a majority vote.
Yeah, so what I think
How
happened
do they
with
do
this,
it?
and I would have to go back and check, but if I remember correctly, there was so much going back and forth. I think this was one of those where they had competing legislation and they didn't hash it out well enough when both passed.
This, I think this also ties into how the state is taking some of the zoning authority away from, I think, cities over 70 or 75,000 people. I don't know the number because there was a lot of interest.
Because they want the multifamily.
Yeah,
Yeah.
there are a lot of legislative changes with regards to zoning that apply to cities much bigger than Colleyville.
Yeah.
And so, yeah, I
If
didn't.
that was some of the compromises to bump it up, so cities like Colleyville Southlake didn't lose some of their local control.
Well, I mean, I think this is what they referred to, and I'm not saying it's true, I'm saying this is what the legislature referred to as the tyrant's veto, and that there were too many instances of citizens basically dictating what other people could do with their property just without any other legal basis other than we don't want it, like not in my backyard kind of thing. So that's what the legislature actually referred to it as, the 20%, and they said, along the lines of the wanting more residential development and trying to deal with, housing crises in bigger cities. All of those things came to account, and this is where they landed with regards to residential development. I guess at 60% would be, the only way I can really advise on how cities handle this is that if there's 60%, then that's when you have to notify. But I think with regards to cities like Colleyville, that staff is gonna keep the PZ and council informed anyway, right? So even though no supermajority is required, when you have a council that listens to their citizens, if there's a whole room full of citizens out there saying we oppose this, doesn't necessarily matter if the law requires a supermajority or not, because typically in cities like Colleyville, you have a council that listens to the population. So I just want, if people start asking about these things, it's just really good to kind of figure out. But yeah, I tried for a long time to figure out why they would even put a threshold on there instead of saying, you know, if it allows formal residential development, then a protest doesn't matter, but they didn't. So it says 60%, and even if you get 60%, nothing changes.
Just go on, keep moving down the road.
Okay, this is not,
Oh, you broke it.
I probably did. Got tired of me talking. Okay, so the Land Development Code sets forth who and or what entities can make determinations about certain waivers, variances, and administrative decisions. And the Planning and Zoning Commission here's the following. Out of all the different things, landscape and buffering, tree preservation, building design, sign regulations, and plating procedures. So with regards to plating, I'm sure you all remember that there is very limited discretion. If the requirements are met, it must be approved. It's very ministerial. Colleyville just still has in its charter that the Planning and Zoning and Council both looking at and review plats. And a lot of cities have changed that quite a bit over the years, but it is a ministerial act. So just a brief update on ethical and conflicts of interest. You know, there's statutory conflicts and then personal conflicts. The notice area for zoning cases is 200 feet. Colleyville extends that to notice to 500 feet. Anytime there's an appearance of impropriety, if you think, oh, this might look really bad, that might be something you want to have a conversation with legal counsel or the city secretary about. Just to kind of make a better decision for yourself, but statutory conflict should always be disclosed, and an affidavit for that disclosure is required to be filed. So what a substantial interest is always kind of up for consideration, right? There are a few things that the law says these are substantial interests, and these are things that you have to recuse for. But then again, there's a lot of things that aren't specifically covered. So if there's a special economic effect on the business that is distinguishable from the effect on the public, or if there's a reasonable, foreseeable, if it's reasonably foreseeable that an action will have a special economic benefit on the property, those are things that have to be taken into consideration. Just more on the requirements of disclosure. Anybody who does business or considers conducting business with local government entities requires those familiar relationship disclosures. Gifts, be aware of gifts. It doesn't matter if they're little gifts or big gifts, always be wary of gifts. All right, so Open Meetings Act. Any discussion or deliberation between a quorum or between a quorum and another person regarding public business requires there to be it is a meeting and it's required to be open. Walking and talking quorums, those are the ones where it's successive, it's never a quorum together. But if a quorum is reached successively through multiple communications, that actually creates a quorum and can lead to Open Meetings Act violations. That's why we always advise, you know, when you get sent things by city staff or from legal advice from the attorney, it's often either a blind carbon copy or at the bottom of the signature page it says please do not reply all, because if you reply all, or if you have an offshoot and you're saying 2 or 3 are communicating about this and then this person goes to talk to 2 or 3 about that, then that's definitely going to lead to Open Meetings Act violations.
Sarah, does the Open Meetings Act apply after a matter is decided by P&Z and it's no longer on our agenda?
No. I mean, anytime there's gonna be a communication about city business, because you're a commissioner, but if you're not acting in your capacity as a commissioner, like for example, if there's nothing on your agenda about a specific item,
We've
and
already
you're talking
voted,
to,
we've already voted, the meeting's over.
right, but so Open Meetings Act doesn't necessarily, I mean, for the Open Meetings Act, yes, but when you're discussing city business, that becomes a meeting, even if it's
Right.
not something that's gonna be up for your consideration again.
Right, but it's not covered by the Open Meetings Act anymore.
If you are discussing city business, it doesn't matter if it's already been decided, if it's city business, then it can be subject to the Open Meetings Act. Alright, so the executive sessions, there's a long list of things that can be allowed in executive session, but legal advice, economic development, real property issues, personnel in certain circumstances, and then prospective donations and gifts to the city. Just with regards to legal advice, just remember, just because a lawyer is present does not mean that that is an appropriate executive session. It has to be for actual specific legal advice on a matter. No action can be taken in closed session. So disclosure of any information that is related or disseminated in executive session, it can eliminate confidentiality to an extent, and it could put the city at risk. So we just advise against it. Same thing here, I won't go through that. Disclosing certified documents from the executive session is an actual offense under the law. The defendant had to have good reason to believe that the disclosure was lawful if they wanted defense to that, and it was a mistake of fact. Any information that an official or commissioner has that the public may not be disclosed to the public is what's covered under that confidential information. Okay, let's see. Yeah, so I mean, again, we advise against discussing things that happened in executive session, but that in and of itself is not unlawful. It's disclosing the actual information, the certified agendas, and the recordings, which would make it unlawful. So the Public Information Act, just remember as PZ commissioners, you are the temporary custodian of any public records. That does include any information that is collected, assembled, maintained in connection with the transaction of city business. So it's your text messages, your emails, your social media, anything, even if it's on your personal devices, if you are discussing city business, then you need to be very cautious with regards to holding onto that information as a temporary custodian under the PIA. Told you I'd be quick. So that's just my brief refresher. If y'all have any questions, let me know.
Could you send us a copy of this?
Sure. Yeah, I can get it to you.
I was gonna say, did you get a copy, since Candace is new, did you get a copy of the bylaws, commission bylaws?
I'm not sure what they hand out when they do their individual.
We're handling that at a
Orientation.
later date.
Oh, okay.
She's
Okay.
covered.
Okay,
Yeah.
alright, good. I just know that that's helpful, kinda explain everything. Okay, we are ready to move to item
You wanna
3.
do the vote? We have to get that done first, don't we?
Do we wanna vote on chair and vice
It's
chair?
gotta be on an agenda, so it'll be at the next meeting.
Okay. So we'll go to item 3, presentation and discussion of replat for blocks 1R, 2R, and 5-7, block 1, Northeast Professional Park, located at 1105 Professional Court and 5301 Colleyville Boulevard, case PC 25-022.
Alright, item 3A, here's an aerial map. The existing zoning is CPO, which is just professional office. Here's a street view, it's undeveloped. Here's some pictometry. Here's the plat itself. The purpose of the replat is to replat 5 lots and dedicate easements necessary for development. Within this proposed change, none of the existing development on this lot right here will be affected. It'll stay in conformance with the CPO zoning district standards. Here's a closer view of the plat. It meets all the requirements of the land development code. And that's all I have to share about the plat. I'm happy to answer any questions.
Picture one more time.
Which
Picture of it.
This one?
Keep going down the photograph, yeah, and then where is it?
So it'll be 4 lots right here. They're changing this lot, so this lot is the 5th lot. So they're creating 4 lots right here, and then this lot's getting smaller. So the 4 lots right here, and this is the 5th lot. This building will remain in conformance with CPO development standards, so they're good. Do what?
It's all commercial.
It's all professional office. Or will be.
And that's consistent with
The zoning.
Automatic approval, pretty much.
It's behind lifetime.
Yes.
Do you know if they have plans, what their plans are, just to?
Medical offices, professional offices.
Okay.
Yeah.
Okay, anybody else have any questions? All right, thank you.
All right.
All right, if there's nothing else, meeting's adjourned.